point, does anybody have any conflict of interest to declare? Or whatever interest you wish to raise, so that the committee is informed before proceeding?
Chair, can I raise this? It's fundamental that we know whether we are dealing with a petition filed by Liberal Party or Liberty Party. These are two different words. And essentially, I mean, as a legal mind yourself, you cannot be listening to Liberty Party when the petition itself is filed by Liberal Party.
Thank you very much. What we do is we'll come to that. Let's just do the preliminaries first. Then after that, we will have clarifications coming along when your turn comes. The next issue to be done is, are there any conflicts of interest to be declared? So that if any member is conflicted, then we need to know the nature of conflict, and so that we take it into consideration while dealing with the matters.
May I take that one, Mr. Chairman? The advocate for Liberal Liberty Party was my first senator in Nyamira and a personal friend known to me. And I must also indicate that I have a personal and business relationship with the advocate for Cherera. The advocates for Cherera, Mr. Nyaberi and Dunstan Umari.
Will that in any way influence your sitting in this matter?
It does not conflict me in any way.
It does not in any way influence your determination of the matter or judgment in the matter. Thank you. Anybody else?
Chair.
Yes.
I do not know how this would be defined, but the advocates on record for both the petitioners and the respondents are people well known by several advocates, including myself. But I don't know whether that should be an interest.
Will it affect your judgment? Will it affect your determination of the matter in any way?
It won't, because...
It won't. Thank you.
Okay.
That's good. I must disclose that I went to school with Donald Kipkoril, University of Nairobi, same time. He's my friend. We've done a lot of work together. We've done everything together. But I repeat, that will not in any way influence my decision, my judgment, and my conduct of these proceedings in any manner. Thank you. As we start, it's vitally important that we state to you, to all the members, members of the public, council, and everyone in this room, a bit of the rules that guide us. And those rules are derived from Parliament's standing orders. They're also derived from a communication from the Speaker. We've not added anything that is materially different from what the standing orders say, nor what we received from the Speaker. The first and most important fundamental point to be made: these proceedings are quasi-judicial in their nature. What that means is that the members of the committee sit here in a position similar to that of a judge. They do not represent any party in whatever manner. They will not prosecute the matter for anyone, nor will they defend anyone in these proceedings. We are sitting as impartial umpires whose role is to listen, and after listening, we will retreat away from the public to make a decision. So that must be extremely clear to everyone, that these members are not holding any positions, whether adversarial or otherwise, as regards the matters before the committee. Number two, we are strictly guided by standing orders as regards the timelines. So if the standing orders say this is the time to be given, we have to live within those periods of time. We can have extensions if requested, but those extensions will again be limited to those periods of time. It it is vitally important that we state proceedings here will remain decorous. Everyone must conduct himself or herself with maximum decorum. We have to be civil towards one another. Even when addressing one another, there shall be no altercations or exchange between any two parties, and all communications will have to be made through the chair, so that you do not start engaging one another in a manner that is unbecoming. Everyone is going to be heard with minimum interventions. In fact, with no interventions whatsoever. Unless where it is necessary, it will be raised through the chairman so that we can take the intervention and then proceed. Let's just confirm everyone is going to be heard in total silence. We will not cheer, we will not jeer, we will not do anything that again is unbecoming. It is important to confirm that under our standing orders, we allow members of the public, including our leaders who are here with us, to sit in and listen. However, members who are not members of the public and are not members of this committee will not participate in the proceedings. They will not ask questions, they will not give evidence, they will not do anything else, because if you want to do so, then you have to remain out, because we have to order witnesses in accordance with our standing orders. If any member, like the members of parliament, wishes to participate, then they have to put their requests in writing and disclose the nature and the extent of the participation which they have in mind. These proceedings are in the open. In spite of the fact that we are in a room, they are in the open. Members of the public are not supposed to be restricted. They have their sitting space inside here. If they can't fit, they will go to the gallery and they are able to observe. But again, they can only observe, they cannot participate. When it comes to time, the discretion to allocate time is purely in the hands of the committee. So we are the ones who will allocate how much time each party is given and how much time the other party is given. As regards the nature of the proceedings, as we have said, they are quasi-judicial in nature, and therefore we will not take sides. If there is any application for extension of time, for whatever reason, we will take it and we'll make a determination regarding it. And we will follow our standing orders, being the primary regulations that we have to use. We'll also follow the statutes, including the Fair Administrative Action Act. And finally, we will also follow the tenets of the Constitution to the letter. Let me also clarify that this is not a hearing per se. This is an investigation in accordance with the standing order, which requires that once a petition is received in the Parliament by the Speaker, he will commit it to the relevant committee that is supposed to investigate and make a recommendation. The real trial, if that ever comes to be, is in another forum different from this one. What I mean by that is, strictly speaking, not every piece of evidence is going to be brought before the committee. Not the standards of proof, whether on a balance of probability, whether beyond reasonable doubt, may not apply to this committee. But it must establish that there is either merit or no merit whatsoever in the petitions that are before us. So, in the legalese, it's just a prima facie case, something similar to that. Just to confirm whether what is before you is anything that can be sustained by a different body in a different forum. So those are the rules. Please On behalf of the Justice and Legal Affairs Committee, let me confirm that we are going to abide by them, and there is maximum control of the proceedings. Thank you very much. Honorable Donya. That is the name. Introduce yourself, please. That's a member of parliament. It's good we get some little audience.
Thank you, Chair. I'm Donya, woman MP from Kisii County.
Kisii County. Thank you very much. Right.
Chair.
Yes, I hear you.
Chair, I wanted to table a document before the committee that on yesterday, on 23rd of November, I wrote a letter on my capacity as the minority whip and a member of this committee to the Speaker. And as what's happened? Mr. Chair, I wrote a letter to the Speaker, the Honorable Moses Wetangula, as the minority whip and a member of this committee, concerning the ground rules that were made by this committee in their previous sitting, which I felt some of them are an affront to the standing orders and the Constitution. And as of now, when I came to attend this committee, I have not received an official response to my letter from the Speaker. And some of the things I've raised are very, very fundamental, Mr. Chair. Some of them are the issues, the rules that contravene the standing orders and even the Constitution. I've raised constitutional issues in the letter, Chair, and I wrote to him, and I did not write to the Chair because issues of standing orders and management of the House through the standing orders and the Constitution lies squarely with the Speaker. To the Speaker that is supposed to guide the House whether the committee is operating or is sitting in conformity with the rules of the House or the Constitution. Because, Mr. Speaker, some of the rules, according to me, even a sub-chief's committee cannot operate under those rules, Mr. Chair. They are very, very derogatory, but I have not received an official response up to now. So I want to table this letter before the committee so it goes on record that I have objected to these rules that the committee intends to operate under until I get a response and an official communication and ruling from the Speaker, preferably on the floor of the House and not even in the form of a letter. Because these are things that are going to send precedents going forward on how committees are going to conduct themselves. If every committee is going to form their own rules outside the standing orders, Mr. Chair, then we are going to have a kangaroo committee sitting everywhere. Let me table.
Thank you. Thank you. Place it on the table. Thank you, Honorable Jeanette. I think I will have to issue a communication regarding that. The letter is addressed to the Clerk of the National Assembly.
No, Chair, to the Speaker.
To the Speaker of the National Assembly. And therefore we expect a response from the Speaker of the National Assembly. As we speak now, I have a letter dated 24th November 2022 addressed to the Honorable Jeanette Mohammed, and a copy is made to me as the chairperson of the Departmental Committee on Justice and Legal Affairs. I believe the mode of communication you chose is to write a letter to the Speaker, and the Speaker chose the same mode of communication to respond to your letter. I will now provide you with a copy of the letter we have received, just the way you have tabled your communication to the Speaker. And in that communication, you will see that the Speaker has actually confirmed what I said are the ground rules derived from the standing orders and derived from his own communication to us. He has therefore confirmed that the ground rules we made are within the standing orders, they are within the statutes, and they are also within the Constitution. In the circumstances, I'm sorry, let me just finish. Let me finish, please, so that To raise the point of order, please.
Yeah.
So, the communication confirms that the rules we made are in respect of these proceedings only, not any other proceedings. Number two, they are derived from the standing orders of our National Assembly. And number three, they are in compliance with the law. So, having said so, I do not think we should carry on the matter further than that, because Junet wrote a letter to the Speaker. He has received a response from the Speaker.
Point of order, Chair.
Junet, that is the last point of order, please, so that we can move on.
Chair, you cannot gag me at all. I'm a member of the committee. I have every right to ask any question, any clarification, anything.
Thank you.
Guaranteed under the standing orders, Mr. Chair.
Yes.
So we are not in a court of law that way you can. First, Chair, we need also to interrogate the matter, because I was supposed to receive a communication from the Speaker, not from the Chair. So me, I don't know whether this letter you're talking about is authentic or it's not. I have an office in Parliament called the Office of the Minority Whip, and I wrote that letter under my capacity as the whip of the minority. So the Speaker knows my office. I have staff there. I have secretariat there. I have people. My office is open 6 a.m. in the morning from every day. So, Mr. Chair, I'm confirming to you here on record that I have not received any official response from the Speaker as of now when I was coming to this committee. And then secondly, Mr. Chair, let us be guided by the standing orders. You know, if you say you're going to make a ruling here as you're talking, to what extent is your ruling applicable, Mr. Chair? Because as you know, a chair is supposed to guide the committee and not to make any ruling. It's in standing orders. You're just supposed to guide us as our chair. But a ruling can only be made by the Speaker of the National Assembly, Mr. Chair. That is why we have members from both sides here who carry votes here, who can decide on an issue, and either way they decide, Chair. So let's not go that direction that I want to make a ruling. Your ruling
Point of order,
a subsidiary
Mr.
one.
Chair.
Mr. Chair,
He's on a point of order. Let me respond to him. Then I'll give you now a chance.
probably me.
Chair, I just want to clarify on some of the issues that Honorable Junet Mohammed has raised. Honorable Chair, I want to confirm.
Before we go to the merits, I
want to confirm that, Chair,
before
the rules.
Before the distinguished member.
Honorable TJ, I'm on the floor.
He is on the floor.
Chair. Honorable Chair, I want to confirm that the rules that we made as a committee are the rules that we agreed. And these are ground rules that we discussed. And when we were discussing these ground rules, we were having the Constitution and the standing orders with us. And we went one by one as a committee. We checked and we ensured that we are in compliance with the standing orders. In fact, as members of this committee, it comes as a surprise that Honorable Junet Mohammed, who was in fact one of the participants in that committee and gave his thinking, which was taken very well by the members and you, Chair, went now behind us and did another communication to the Speaker. I'm actually surprised that he did not agree with us and he did not raise it in the committee, because when we left the committee, we seem to have been in agreement. And now, in the situation where now he has raised a communication to the Speaker and the Speaker has responded, then I think he should be able to take that. And as a committee, we should now move to the...
Sorry, Honorable Junet, you're out of order. Out of order.
We should move to the business of the day. The petitioner is ready and he's raring to go. And since we have said this is not an adversarial kind of a hearing, let the petitioner explain himself, and then we go to the next petitioner until we clear the issue at hand.
On a point of order.
On a point of order, Chair.
Sorry.
Chair, on a point of order. Because you raised fundamental issues with me that I agree.
Sorry, Honorable Junet, you're out of order.
Chair, I want to...
You're out of order.
Can I be recognized?
You're out of order.
Can I be recognized, Mr. Chair?
Well, it's not a demand. It's for me to rule. I am on the chair. It's as follows. Honorable Junet, you say you wrote to the Speaker.
Yes.
And the letter was not copied to us.
The letter was never copied to you.
It was not copied to us.
Yes.
This morning, you have elected to table the letter before us.
Yes.
The same way you have tabled the letter before us, the same way I have tabled the response from the Speaker, and I've given you a copy. So because of that, the issue of the letter written by Honorable Junet and the response from the Speaker is actually now decided. And I think,
Mr. Chair, just a minute. I think I need to be heard now. I need to be heard. I think I need to be heard. Yes, I think I need.
Honorable Kajwang,
may I be recognized?
Honorable TJ, you are out of order.
May I be recognized, Mr. Chair? May I be recognized before you make a ruling on this?
Can you,
Mr. Chair, you are referring to a response which we don't have. What I see here is some writing without signature. I am unable to tell if this is the signature of the Honorable Speaker. And so we do not have this response that you're talking about. Could we have the response and be able to evaluate it against the letter that Honorable Junet is purported to have written, so that we may evaluate this issue with some consideration, Mr. Chair?
Honorable Chair.
This is what I want to say.
Honorable Chair.
I have heard you.
Honorable Chair. Just a minute.
Honorable Soro, please. I've heard you, Honorable TJ. Honorable TJ, this is my copy of the letter. It is not the original. Number two, we will deal with these issues ourselves internally. For now, we are here for a hearing. Honorable Junet, you are out of order.
No, Chair, I am the owner of the letter.
You are out of order.
I wrote to the Speaker. How can I take a response which is not signed by anyone?
Honorable Chair.
You wait for the response.
So this must be from River Road, Chair.
Thank you.
Speaker signs officially.
Thank you very much. Thank you very much.
This must be a big letter.
The matter is now closed.
Honorable Chair, as you close the matter, Honorable Chair, kindly, Honorable Junet says he wrote and addressed the letter to the Speaker. He hasn't received a response. From where I sit, Honorable Chair, I believe that we need to withdraw both your letter and his letter from this committee. We are not parties to such letters and responses. We are not party to that. He should complain to that relevant office, the Speaker's office, on why he hasn't received any response. We should withdraw both letters and proceed with our proceedings.
Thank you very much, Honorable Soro. The issue of the letter written by Honorable Junet and the response by the Speaker, whether from wherever he thinks it came from, is a matter we have decided on, and we now move on with the proceedings.
How have we decided on it?
That we will leave it as it is. Honorable Junet is prepared to go to the Speaker's office. If he doesn't believe in the response, he will get it from there. It does not involve this committee. Thank you very much.
But may it go on record that my complaint to the Speaker will affect what the committee is doing? On record.
It is on
those rules we are using here.
It is on record, and when we retreat, that's part of the issues we will consider.
If at all, we shall retreat.
Thank you very much.
Mr. Chair, if you indulge.
Thank you very much.
With a lot of respect.
Honorable TJ.
If you indulge me.
Honorable TJ, please, order.
I'm having.
We are going to invoke the standing orders.
No, just a minute, Mr. Chair. You see, until I am, if I am within the squares of Standing Order 107, as a member for Waraka and as a member of this committee, I'm entitled to be recognized. Mr. Chair, I with a lot of respect, consider that you have made a ruling. But you see, Mr. Chair, that is not how committee work is done. Because rulings of a matter in such as this that touches on the nature of the issues that we are considering is a matter that must be left to committee members to make a decision on, either by way of consensus or by way of vote. The chair is a presiding officer, will guide the proceedings, but the chair does not have a casting vote. The chair is unable to make a ruling on a matter until the members of the committee, I suggest, probably Mr. Chair, that you relieve people who are not members of this committee to go out so that we make a decision on this, because that is how standing orders work and that is how proceedings in committee work. Thank you, Mr. Chair.
You are heard. I invoke standing order number 180. Read standing order number 180 as to what the chairperson of the committee can do. Having made that invocation, we will now proceed. We call upon the petitioner to make the presentation on behalf of the Republican Party.
With your kind permission, Chair, we are here representing respondents. Can we be heard? My name is Dan Sanomari. you have not given us a right to be heard as those representing the respondents. We have preliminary issues that we need to be heard. The committee members have raised their preliminary issues. It's not that we are here not to raise concerns of our four respondents. Could we be heard?
First and foremost, it has to be brought to our notice that you have preliminary issues to raise as counsel for the respondents. That's number one. Number two, we have to take a decision as regards when we should be taking those issues, right? Is it you want to raise before the petitioner makes the presentation? Yes,
Mr. Chair.
That's what I want to guide you on. Is it before the presentation is made or after the presentation is made?
Chair, we have preliminary issues before they start. They need to be addressed. They are pertinent before the petitioner takes the floor. The petitioner is alleging serious allegations against our clients. We need to raise the pertinent preliminary issues. Preliminary issues are issues before the investigation starts.
Thank you, Counsel. But we need to know who amongst the respondents has preliminary issues to raise. That is number one. Number two, are the preliminary issues in writing? If they're in writing, we shall be drawn, our attention is going to be drawn to those particular documents. Number three, we want, at least it's not we, because unless we are leading the rest of the council, it should be only one petitioner so that we know exactly who is raising an issue and how it's going to be addressed. Are the issues common to all the petitioners or it is to one petitioner? So I think, council, you have to tell us on whose behalf you're making the PO and whether it is in writing or it's oral.
Chair, what we were seeking for is time. You've heard your members. You have not heard from us. Now that you have given us time to raise issues, the lead counsel will start on the question. All that we were seeking is time to breathe, time to talk, time to be heard.
Thank you. Just before you take on, I would not have heard you because it is not your time to be heard. It's time for the petitioners to be heard. However, if there is a PO to be raised, we are prepared to take it, and you've made an allusion to a lead counsel. It means it's one counsel who is going to raise it. And on whose behalf? Is it on behalf of all the respondents or on behalf of one respondent?
There are four respondents, each represented ably. So we have Arwa starting for his client.
So we have four counsel making POs.
That is the right, correct.
Without repetition.
That is correct.
Thank you very much.
Thank you very much.
So the time we allocate for any PO to be raised is a maximum of 5 minutes per counsel. So
we stand guided.
If it is Advocate Chotham Arwa who is beginning, we give him 5 minutes, but please there should be no repetition. Because if there is a repetition, I invoke my inherent jurisdiction to say that has been argued. It has been presented. So we listen to you so that, and I remind you of the various court decisions that preliminary objections are usually on points of law. They are not on matters of evidence, on matters of fact. So as you proceed, please note it has to be on matters of law and not evidence.
Chair, on a point of order. Thank you, Chair. I appreciate the issues being raised by our colleagues on the other side. They want to raise a preliminary point of order. May I know from the Chair whether that notice of preliminary objection has actually been served on the parties or is basically ambush? Yes.
I think let's listen to it. Then after that we shall be able to make a decision on it. It's purely procedural, it may be in writing, it may be oral, whichever way, we will give it the fair consideration that it deserves. So let's give Jotham Arwa the floor. Please, let's have minimum interruptions now.
Thank you, Mr. Chair, for giving me the opportunity to speak, but I would like to begin by making a request. You directed that the PO be raised in 5 minutes.
Yeah, that's what I want to do.
But I believe that the PO that I have cannot be raised in 5 minutes. Mr. Chairman, the substance of my PO is that this committee has no jurisdiction to entertain any of the 4 petitions. And I have a total of 10 grounds. Now, it is not practically possible to argue even one of them in 5 minutes. I would therefore humbly request...
I'll stop you slightly.
Yes.
As when it comes to allocating time, our standing orders grant that to us. And number 2, your PO, if I'm not wrong, is in writing. We have it written. And this committee actually is able to read. So in 5 minutes, just summarize why the committee lacks jurisdiction, because that goes into the core of what we have before us.
Thank you, Chairman. I stand guided. But I wish to point out that first, as I've stated, this committee is listening to hear a very important complaint against a public officer, a complaint that seeks removal of a public officer. And it is proper that the committee should be guided by the provisions of its own standing orders and the Constitution. All the 4 petitions, Mr. Chairman, cite provisions of the Public Officer Ethics Act. And this particular legislation, Mr. Chairman, at section 35, prescribes a procedure that is supposed to be used to deal with cases of misconduct by public officers. And it states very clearly that such complaints should be addressed to a commission that has been created under that act. And with respect to commissioners of IEBC, Mr. Chairman, section 3 of the Public Officer Ethics Act clearly states that a complaint concerning or seeking redress in connection with misconduct by a commissioner of IEBC should be addressed to the Committee of Parliament that is in charge of matters to do with the ethics of members. I refer you, Mr. Chairman, to page 52 of my preliminary objection. I have annexed the legislation. And if you read section 35, it says that the complaint should be referred to the commission. And if you go to section 3, it prescribes the relevant commission that is responsible for dealing with complaints against IEBC commissioners. And that is the committee responsible for the ethics of members. Mr. Chairman, I have also referred you to your own document, that is National Assembly document that deals with the conduct of members. And it appears, if you look at page 23, you will see that the relevant committee of the House that deals with the ethics of members is the Committee of Privileges. Mr. Chairman, this is your own document. So if you read that provision and you look at the Act, then you will see that the right committee that should entertain these complaints is the Committee of Privilege and not this particular committee. Number 2, Mr. Chairman, it's a requirement of your own standing orders, number 2223F, that before petitions can be received, they must indicate that they had complied, they had referred the matter in question to the relevant body. It means, Mr. Chairman, that Parliament should not be the first port of call for any complaint against a public officer. In this particular case, as required by your own standing orders 223F, as read together with 234, pursuant to which these proceedings are brought, the complaint should have been forwarded first to IEBC, and next, and more importantly, Mr. Chairman, to the Public Service Commission that has got a mandate to deal with conduct of public officers pursuant to Article 234, Sub-Article 2, Paragraph B. Your standing orders require that you abstain from entertaining any such complaint unless the relevant body has been given the opportunity to deal with the issue. Mr. Chairman, there is also the question of immunity by public officers. And this is provided for under Article 250, Sub-Article 9. And it says, public officers or members of independent commissions, when discharging the mandate of their office, are completely immune from proceedings such as this, especially when they act in good faith. And in this particular case, the contention that has been put, Mr. Chairman, is that they were discharging the functions of their office. And therefore, the Constitution accords them absolute immunity. And therefore, we cannot initiate these proceedings. Mr. Chairman, I've also heard you mention that this is a quasi, it exercises jurisdiction that is both administrative and judicial at the same time. I wish to remind the committee that it is bound by the provisions of Article 50, Sub-Article 1. Article 50, Sub-Article 1 states that any person is entitled to a fair hearing before a court, before a tribunal, or before any other body that is making a decision that is likely to adversely affect the interest of anybody. And it's therefore important that you appreciate that you are bound by this particular constitutional provision to ensure that whatever proceedings that you conduct meet the minimum constitutional requirements. Now, in this particular context, Mr. Chairman, it is not conceivable that you can invite the respondents to come and defend themselves of allegations that they cannot even understand. Mr. Chairman, we have explained, we have sent letters to the clerk. We have sought clarification as to the nature of the complaints that are raised, and we have not received any response. Mr. Chairman, we have inquired whether we will be allowed to call witnesses. We have not been told. We have inquired whether we will be allowed to cross-examine the main complainant in this case, Mr. Chairman. And the main complainant, in our view, is none other than Wafula Chebukati. All the complaints basically reiterate the contents of his affidavit. Now, how are we supposed to engage with a petitioner who is merely reciting what he read from Wafula Chebukati's affidavit?
All right. Thank you.
At a point in time when we have not been given the opportunity to test the veracity of that, those allegations.
Thank you very much.
Chair, point of order, Chair.
Point of order, Chair. Please.
Point of order, Chair.
Jeanette, please.
Chair.
I've not given you the floor.
Yeah, let me invoke Standing Order 180, as you've just said. Chair, you know, the committee must do their work through resolution, Chair. Even when we're in the plenary, you know, when the Speaker wants to allocate time, he asks the members, do we make it 5 minutes or 10 minutes or 2 minutes? It's not unilateral decision, Chair. So these people must get good time to put up their matters, Mr. Speaker.
Thank you.
It's a serious matter for the committee.
We've had you.
Yeah.
We've had you. Take a seat. Thank you.
Through
Honorable Arwa,
on a point of order through the chair.
Who is okay? Who is
my name is Geshamba.
Sorry.
My name is Geshamba. I represent Francis Wanderi.
Are you the next one?
No. I just need to indicate to the House that I would wish to donate my 4 minutes to my senior, Mr. Arwa, who might be able to probably finish what you're submitting on.
So, let's not take such dilatory positions, please. These are serious proceedings. Before, you said you are 4 of you, and you're going to take each 5 minutes. You should have agreed up front that one person will make take the 20 minutes.
Mr. Chair.
So, sorry, I have to guide. Sorry.
Can I?
Honorable TJ, you're out of order. Who is the next person?
It's interesting that every time I stand, I'm out of order, even when I don't.
But you can't also bulldoze.
Well, but you see, I must be recognized unless you want to make proceedings which are adverse to me. Mr. Chair, we are handling a very important issue in this nation. We must be seen to be fair. We must be seen to apply our minds to the Constitution and to be able to know the thinking of the members of the public, because here we represent the public. This is not a court of law. Here we represent the hearts and minds of the public out there. Now, an issue has been raised by the respondent. And we, of course, I have made myself comfortable with the fact that I am here to listen and not to prosecute, right? But I think that these people need enough time to be able to bring their issues out. As you see, these are legal jurisdictional issues. The lawyers are very distinguished. The lawyers are looking at the law and no sideshows. So I propose, Mr. Chair, because when I rose in the first time, I said that decisions in this committee should be handled in a consensual way by members of the committee, not the chair per se. Even an issue such as time needs to be handled because it is important. I propose, without taking you around, I propose that every of these councils should have 10 minutes. Minimum, to be able to prosecute their issues with very little interruption. Thank you, Mr. Chair.
Honorable Chair, I think if we operate or if we move on the way we are moving, we risk to be seen as if we have not had a chance to have a communication or to have a consensus on how we are going to move. I think we have had sufficient time from last week as a committee to be sincere. We have talked, we have raised these issues, we have discussed as members of this committee, and we had taken a position as a committee that we have come up with a program in which our petitioners and also the respondents are going to be handling themselves. And I think up to now, what I'm seeing is a lot of interjections, which to me are basically derailing this process. And if we as members of the committee do not think that the chair should give direction as a chair, then we seem to be negating our own mandate as a committee. Because Honorable TJ, Honorable Junet, I think we as the members of committee must agree we had talked and we had agreed on whatever we have on the floor. But again, at the same time, we must also agree that the chair should also guide. If the chair does not guide the process, then we risk being disorganized and being disorderly. So for me, I think I support
Honorable Kagusha, thank you very much.
I support the decision.
Your point is made. Honorable Junet, please.
Chair, please.
And if at all we have, we completely have a problem with the decisions of the chair, then I think the honorable chair, the only honorable thing then to do is to retreat as a committee and look at the issue of how we handle the emerging issues.
Thank you.
Thank you, Chair. Chair, just I wanted to bring to the attention of the committee.
Honorable Junet, you have to be given time.
Standing order number 180, Chair, says that subject to the provisions of the standing orders and the directions of the committee, a chairperson of a committee shall A, preside at the meeting of the committee. Preside. 2, perform the functions and exercise the powers assigned to office of the chairperson by the committee resolutions. But Chair, what I want to say, I know my brother was the speaker for Nyeri County for many years, but you know National Assembly standing orders are superior to the county assemblies. So Chair, I want to say this. Chair, we must guide the committee. You must preside over in accordance with the standing orders. Chair, the issues being raised by these lawyers who are representing here the respondents, are very weighty matters that will inform your decision in the end.
Absolutely.
So if we give them 2 minutes, 3 minutes, Chair, 2 minutes, you can only say your name and say, I come from this village. You cannot say anything. Yeah?
Thank you, Honorable Jeanette. I've heard all of you. Let's move on, please. I got to preside. I'm presiding. So what we do is, I've had Honorable Kagusha, I have had Honorable Jeanette, I've had TJ. Vice Chair wants to say something.
Yes, Chair and all council present and members, for the information of the Honorable Jeanette, the word preside means to be in a position of authority in a meeting or other gathering. That is the meaning in the dictionary.
Okay. Thank you very much. Sorry, we've had you, and we said we observe decorum.
But again, Honorable Chair,
we have to observe decorum.
Honorable Jeanette must also show the members of this committee respect and decorum. I want to inform Honorable Jeanette that the standing orders of county assemblies are also superior. In fact, as a member, as a speaker of the county assembly, we observed the standing orders in a better way than the way Honorable Jeanette.
Thank you very much. Absolutely. Let's not drag this on further. No. I'm sorry, Honorable Jeanette, please go out of order.
Chair, this House of Records, your Vice Chair here is claiming that presiding over a meeting is having authority. I don't know where he's getting that. It's not the
just where you got your own opinion.
No, I read for you 180.
Thank you very much. He will tell you just shortly. Thank you very much.
Chief of Staff of Mutua. That is no different here.
I think you must.
And unfortunately, Jeanette, you have to conduct yourself with the decorum. If you're going to be we are looking at the idiot here. All right. Sorry. Vice Chair, I've had Honorable Kagusha, I have had Jeanette, I've had Honorable TJ. We will stick with the earlier guidance I gave, that it will be 5 minutes per council. If there's anybody who is donating time, now donate to the next person. Honorable Donald not Honorable, Mr. Donald, now you're Doctor Donald Kipkoril, so that he's able also to present his PO. Sure. Please let POs not be repetitive, and let us move on. So the floor now.
Take it that our presence here is. Do we take it that our representations and our presence here is not useful?
We shall deliberate over that ourselves.
That is not a matter of deliberation. That is a matter of procedure, because we are in.
Donald Kipkoril, you have the floor.
No, Mr. Chair. Mr. Chair, on a point of order, I don't have to stand up.
Sorry, you don't have to stand up. Yeah. But I have not allowed the point of order.
Let me speak. No, a point of order, Mr. Chair. Fortunately, a point of order does not need to be allowed.
All right.
A point of order is something which comes to a member's mind.
All right.
Every member has an opportunity to put a point of order at any time. Honorable Farah will tell you, who has been a speaker here for so long, that a point of order is an issue of intervention that comes to the mind of a member at any time. So it is not an issue for which a speaker or the chair will recognize.
Make your point of order.
I am asking. We have raised issues, and we are hoping that the chair is listening and is able to give guidance. But every time we speak, we go back to where we are.
Good.
Are we saying that members of this committee do not have an authority, do not have views which they can express, and which then can turn into issues that we can deal with?
Chair, thank you very much. Chair, I have listened to...
Chair, please.
Honorable Soro, please.
No. What I'm suggesting is that because this is a house of democracy, we appreciate the fact that we appreciate your seat. But I want us to now take a different trajectory altogether in making decisions, generally. They have raised an issue about adjustment of time. And the chair feels otherwise. Being a house of democracy, we are very few here. Let's take a vote. If it's 5 minutes, we agree. If it's 10 minutes, we agree. And if the 5 wins, they keep quiet. If it's 10 that wins, we proceed. We are only 10 of us. Let's just take a vote.
I do not think we need to be taking time on such matters which actually are within the discretion of the chair. We agreed on how to do it, and it has to be that way within our rules. I will listen to Honorable Farah, then I'll make a I'll make a direction, a guideline on what is to be done so that we move on. Because even if you try to delay this as much as you can, I don't think that is going to achieve the objective. Honorable Farah.
Chair, mine is I can see the precarious situation the whole thing is going, but let's also keep our heads very cool. And my suggestion is that in the event one of the councillors there who has his own time decides to donate to somebody, please let's not force him to donate to somebody else. The Arwa was there and the next speaker wanted to donate his 5 minutes. It's the same time altogether. I beseech you, allow him to donate it to Arwa and let Arwa conclude his own presentation right now. And then we continue from there.
Chair, did I understand the council? Now, Arwa, you represent?
Mr. Chairman, I represent Commissioner Justice Nyangaya.
Nyangaya.
Yes.
You represent?
Mr. Chair, I represent Commissioner Francis Wanderi.
Wanderi. Yes. So Wanderi donates his 5 minutes to Nyangaya.
Through the chair, my 4 minutes. Because
4 minutes because you will have 1 minute.
Something to
add to it.
In the event that nothing is captured.
Members,
not all things are captured.
Members, by consensus, we can agree because we are 20 minutes. The objection has to be done within the 20 minutes. And it's 20 minutes. That's what we had said.
That's okay for us, Chair.
So let's carry on.
It's okay, Chair. It's okay, Chair. Chair, these are very serious people. And some of them, you went to school with them, you say. So, Chair, 20 minutes is not enough for people who are very...
Is 20 minutes enough for the committee?
It's 30 minutes.
Let them be 30.
20 minutes is enough.
30 minutes.
Let them be 30, Chair.
30 minutes, Chair.
Because I believe...
How many say 20 minutes?
Chair, can I say something?
How many say 20 minutes?
Chair, can I say something from practice before
please.
we go that way? Chair, I remember I chaired the plenary one time when Honorable Kimunya was being censured. And because he wanted more time, I gave him the more time because you can understand the gravity of the people who are here. So if we say 20 minutes and 30 minutes, the difference is 10 minutes. So let's allow them so that they can see that they have the justice that they need.
Thank you.
Okay, thank you.
Thank you. I think it makes sense. We take it from senior member of the House. Let it be 30 minutes. We will have 4 more minutes donated to Arwa. Arwa, you have your 4 more minutes to continue with the objection. Then from there we hear Donald. After that we hear who? Apollo.
Yes.
Let's agree on the timing. So you have 9 minutes. Out of that remains 21. 7. No, not 7. 7 divided by 2 is 10. Because he still has his 1 minute. So I'm dividing 29 minutes. Time is not running as I talk. All right? So it is how many minutes? He will have 9 or 10. We'll give you 10, 9, or 10, 10. Apollo, yes. You have 9 minutes and you have 1 minute. Is that okay?
I shall take that, Mr. Chair.
Thank you very much. So he has his, let's have his 5 minutes to finish, then you have your 10 minutes. Thank you.
Thank you, Mr. Chairman, for your magnanimity. I was at the point where I was talking about the obligation on the part of this committee to ensure that its proceedings meet the constitutional standard of fair trial. Mr. Chairman, the constitutional standard of fair trial requires that this committee gives everybody an opportunity to understand the question that the complaint that is raised against him before he can be called upon to defend. Every person accused, Mr. Chairman, must also be given adequate time to present his or her own defense. Third, there is the right to give evidence and the right to challenge evidence. All these, Mr. Chairman, are found in our own constitution. Now, with regard to the right to be given sufficient information to understand the charge, Mr. Chairman, there is a lot of problems that we have noted with the complaints, and I have captured them in my preliminary objection. Mr. Chairman, you cannot call someone to come and defend himself for proceedings that he barely understands. And I've given examples on the part of Mr. Justice Nyang'aya. One complaint that is raised against him by virtually all petitioners is that he was present and he agreed with some proposals made allegedly by Amos Wako and Raphael Tuju. His position is that he was not present in that meeting, and he has requested for guidance for the CCTV footages that would actually prove that he was not there. Now, if he was not there and he agreed, Mr. Chairman, he needs to know what medium did he use to communicate his agreement. Mr. Chairman, this is a critical question that he needs to know before he is asked to defend himself, because he was not there, and the footages which happily Bomas of Kenya has agreed to provide will confirm that. Mr. Chairman, there is the right to be given adequate time to present one's case. This is an issue that is arising even as we are here in this room. Mr. Chairman, in your own standing orders, you have provided in standing order number 230, sub rule 4, that each petition should be heard within a period of 14 days. My client is facing 4 petitions, and according to the standing order, each of them should be heard within 14 days. Mr. Chairman, these standing orders are made by this House, and they are intended to protect the rights of the parties. Now, it is not possible, Mr. Chairman, when the Constitution gives you the obligation to ensure there is fair trial, and then the standing orders gives you the power to give 14 days, then you limit my client to a maximum of 1 hour. Remember, Mr. Chairman, his life, his career is on the line. This committee should be seen, Mr. Chairman, not only to be doing what is right, but more importantly, to be upholding the Constitution. Then there is the issue of the right to present evidence. Mr. Chairman, this is a right that is guaranteed under our own Constitution. And you can only present evidence when you know the evidence you are going to meet. None of the petitions, Mr. Chairman, contained any evidence. You are calling us here to come and cross-examine the petitioners. It is expected, and we have litigated with you. You cannot challenge evidence that you don't know. And that is the reason why the Constitution makes it mandatory that you serve me with the evidence you are going to use against me, so that I can prepare with my advocate, so that I can come and cross-examine you. You are calling us to come and cross-examine him. We don't know what he's going to say. I have not prepared with my client on the content of the evidence he's going to give. So the entire process, Mr. Chairman, violates the Constitution. And I do not expect that my good friend would preside over proceedings that do not uphold the Constitution strictly. Mr. Chairman, there is the question of the right to challenge witnesses. And I would want to argue, Mr. Chairman, that the person being challenged here is the author of the document on which all the petitions are anchored. And that is none other than the chairman of IEBC. Every petitioner recites the content of his affidavit. Asking this gentleman here a question regarding what allegations that were made by the chairman of IEBC is futile. I've given you the example of my client who, as a matter of fact, did not attend the meeting which is alleged to have attended.
Counsel, you're on matters of evidence now.
But allow me just to finish with one point.
All right, half a minute.
Yes, Mr. Chairman, there is the petition by Geoffrey Langat, which does not require or ask this commission to remove my client. I do not think this committee has the power to entertain that petition under your own standing order number 230, because it is not a petition seeking the removal of a commissioner. It merely requests you to deliberate. And that therefore means that that particular petition is incompetent and ought not to be heard. Thank you, Mr. Chairman.
Thank you very much. I have some lights in front of me. Yellow means you have 2 minutes.
Okay.
When it goes on, I'll just give you half of that. Red means you have 1 minute. So once you see that, you know you're being notified not to be speaking after the time lapse. When I put it off, it's over. Donald, you have 10 minutes.
Yeah. Chairman, when my client was served with the petitions last week, she gave me copies of the petitions. I immediately wrote to the clerk of the assembly to confirm those petitions. The one by the Republican Liberty Party is 22 pages. The one by Reverend Dumbi is 31 pages. The one by Geoffrey Langat is 5 pages. And the last one by Award Steve Jerry is 6 pages. Those pages are very important, Mr. Chairman. Once the whole House of Parliament or a committee basically constitutes itself into an impeachment proceedings committee, it becomes a court of law. And the basic principle of law is parties are bound by the pleadings. So the 4 petitioners are bound by the pages I've referred to. Mr. Chairman, in the South African case of the removal of the Speaker Delile, which has been referred by by our court so many times, and also the decision of our constitutional court in which they quash a decision on the JSC. Both decisions of South Africa and our constitutional court arrived at the same basic decision that once you're doing impeachment proceedings, you are bound by basically our laws. And the High Court and the constitutional courts have a right to supervise what you're doing. In response to, Mr. Chairman, in response to those 4 petitions, I filed the POs on all the 4 petitions. And I urge you to refer, when you retire, to all the grounds I've set out in my preliminary objections to the 4 petitions. Just in a summary, Mr. Chairman, the petition by the Republican Liberty Party, it's on behalf of the party, but it's signed by Mr. This one, the signature of the person is purporting to be the chairman of the party is Zakaria Matayo. But Your Honor, Mr. Chairman, if you look at Section 16 of the Political Parties Act, a political party is a corporate body. There is no way a person purporting to be a chairman can sign a petition. There is no seal of the party. There is no confirmation or evidence that the party is set to pass a resolution for that Mr. Zakaria to file this petition. The other issue which cuts across all the petitions, Mr. Chairman, is the petitioners referred to so many articles of the Constitution and the articles of the IEBC Act, the Leadership and Integrity Act, and the Public Office Ethics Act. Such petitions, Mr. Chairman, are muddled, they're expansive, they're ambiguous, and they're superfluous. As I've said before, again, you're bound by the laws of this country. Our respondent needs to be given a case that has clarity, that is specific, that he can be able to answer. There's no way you can answer such petitions which basically they go from Article 1 to Article 255 of the Constitution. There's no way you can answer such a question. So, you can answer such a petition. The other issue, Mr. Chairman, is none of the petitions is supported by an affidavit. A petition of such nature cannot be a statement. It can't just be a petition. It has to be backed by an affidavit that deposed to every allegation of fact in the petition. None of them is available in all the 4 petitions. Your Honor, impeachment proceedings, are the highest kind of legal proceedings against any individual, because basically it ends someone's career. And you cannot base a petition on statement that is not evidence in an affidavit. Your Honor, Mr. Chairman, there are 3 allegations against my client: serious violation of the Constitution, gross misconduct, and incompetence. There is no evidence whatsoever on those allegations against my client. Your Honor, the other issue is again, as I said, you're bound by our Fair Administrative Act and Chapter 5 of the Constitution. Where again, across the 4 petitions, you can see that they are coming from a political bias. And that's again an ingredient in our legal system. Where a petition is motivated by bias, then it's not sustainable. You can see basically they are coming from the same political side. Finally, Your Honor, I don't want to take it too much. If the clerk was magnanimous enough to send me all the 9 decisions of this parliament from 2013 until now, all the 9 of them, only one actually succeeded, went through, the JSC one. But still the High Court quashed it. So basically the history of this parliament, none of the impeachment proceedings has been concluded. And just to take you back in history, impeachment proceedings began in England in 14th century during the reign of King Richard II. It was basically intention of parliament to rein in the king without annoying the king. But then in 1795, that was the last impeachment in England, and England ended impeachment proceedings. So there are no longer impeachments in England because they realized the futility of impeachment when there are alternative remedies, which Mr. Arrow has argued, against a public official. We took our legal system, our laws from England. England has moved away from impeachment because it's a waste of time, it's a political tool, it's not a legal tool. It was supposed to rein in public officers for being corrupt, for being incompetent, and for treason. And now we have legal systems that are developed that deal with such errant officers. We have the Public Officers Ethics Act, we have the Corruption Act, we have the Penal Code. So basically, again, as such, if you go through my objections, we have alternative remedies, and this parliament should no longer be taking its time in impeachment proceedings. And Mr. Chairman, finally, as the petitions are not based, they are not supported by any affidavit. They are gossip, hearsay, and to paraphrase our Supreme Court, it's hot air, and they should not be allowed. They should not be entertained. They cannot be allowed to bring additional evidence. What they have filed is complete. I urge Mr. Chairman of the committee, when you deliberate, you go through the petition, you strike them out. And finally, Chairman, I was just saying that because we didn't have enough time to argue our case, if we'll be able to submit a case law, because I have so much case law supporting all the issues I've raised in our objection, I can supply the committee with a case law, and then so that when you're deliberating, at least there is supporting law.
Thank you. But impeachment still remains part and parcel of our Constitution. So it is not illegal.
It's not illegal, but I'm saying even in England, they moved away. It's not, but it's still in the law in England.
We
it's still in the law, but they stopped practicing it.
Yeah, but it's not. It's still part and parcel of our celebrated Constitution.
It is in the law, and
right.
Yeah, in England.
Thank you.
But they don't.
Thank you very much.
Yeah.
Thank you. Apollo, you have how many minutes? Yours are now done 20.
Yeah.
Or you?
No.
You have 9.
Yes, I have 9
minutes.
Yeah, whatever remains, we will give them to our lead doctor.
9 minutes.
Let's
start. Thank you.
Thank you, Chairman. First of all, let me first congratulate the members of this committee who are duly elected by IEBC, the commissioners of which we know. So the commissioners who have been brought before this committee are the ones who conducted the elections that elected the members of this committee to Parliament. Chairman, I also want to adopt the submissions made by my learned colleagues with the necessary modifications as it may be to Commissioner Juliana Cherera. Now, Article 250, Sub-Article 9 of the Constitution, that is where the immunity of commissioners are. And it states very well that a member of the commission or a holder of an independent office for anything done in good faith in the performance of the function of that office, they shall not be victimized. And when you retreat, please look at Article 50, Sub-Article 9. And that one is for all the 4 petitions. Now, going straight to each individual petition, some have been, I don't want to be repetitive, but let's start with the first petition by Republican Liberty Party. The petitioner is different from the signatory. The petitioner is Republican Party. Then it is signed by Zakayo Matayo. So there is no petition there. Honorable Chair, let's go to petition number 2 by Reverend Dennis Ndwiga Zumbi. Again here, this petition falls flat on account of Article 250, Sub-Article 9 of the Constitution. Pardon? Yes, that is the immunity section that you cannot hold against the commissioners who are doing their work and did their work in a fairly and in good faith performed their function. Honorable Chair, the drama starts with the petition by Geoffrey Langat. Now, Geoffrey Langat, which does not pray for any removal first of any of the commissioners, but refers to somebody, one Juliana Cherere. There is no such a person in IEBC called Juliana Cherere. We have Juliana Cherera, not Cherere. So the removal here is not of Juliana Cherera. Here we have Juliana Cherere. Probably by the time they are making their submission, they'll tell us who that person is. And of course, we will not allow any amendment to this petition. There they are. Now, again, Honorable Chair, if you look at the petition by Owur Steve Jerry, again, seeking removal of an unknown person, Juliana Cherere. There are no such officers by that name in IEBC. The sum total of my submission is that there is no petition before this House, before this committee, capable of being investigated. And the last issue that I want to speak about is what my learned colleague, Dr. Arwa, talked about. If at all this committee was to be seized of this petition, there is a very elaborate procedure that should have been followed, including going to PSC, including other forums before finally landing where we are right now. And if at all again this committee was to be seized of this petition, what they have to do first was to lift the immunity in Article 250, Sub-Article 9. As far as we are concerned, such immunity has not been lifted. Your Honorable Chair, I donate the rest of my minutes that are remaining to Danstan Omari.
Thank you very much, Chair.
If you represent Cherera?
Yes.
And he represents
the three of us, yes.
Yes. It's left 2.
How many more minutes, Chair?
2.
Yeah. But you can indulge us with 1 minute. Others are a minute. Chair.
No problem. Give you 3 minutes.
Thank you very much. Chair, the sum total of the submissions of my colleagues is that procedurally this motion has not met the threshold to be admitted. 2, under the parliamentary standing orders, these petitions are 4. Our client is supposed to have been given at least 14 days for each petition. Cumulatively, that should be 56 days. That has been waived purely because our client, who is the vice chair, is supposed to be handed over power after the retirement by the current commissioner, the chairman of the commission. So we urge this committee not to fall into that political trap, to move so fast, and recommend so that a tribunal is set to remove the current vice chair. Every indication looks at that. The legal requirement, the constitutional requirement have been intentionally been flouted to allow the current chair to continue in the absence of the 4. May that be taken very seriously, that this country, this commission, this JLAC is holding the country at ransom. The decision of this committee is likely to impact this country in a manner unknown as serious constitutional crisis. The free-serving ones are leaving. The 4, there is a political intention to remove them. We are heading to a serious national crisis. May the committee see deeper than what is being put here.
Chair,
Thank you.
Chair,
allow him so that he can be paid 1 minute.
Just less than a minute.
As we are paid, we represent. Let him put one word.
What is he putting? He finishes.
No, he has only one word. He has
one word.
Only one word.
All right, so that we are fair. Let's be fair to Apollo. Apollo, 1 word. Half a minute.
Thank you, Chair. I want to invite the committee to the Oaths and Statutory Declarations Act, Chapter 15 of the Laws of Kenya. Now, the petitioner that is the Republican Party, Liberty Party, has alluded to evidence which largely is pegged to the chairman of IEBC affidavit that he presented before the Supreme Court. He has not presented evidence by himself of what he knows by himself in regard to the conduct of the vice chair of the IEBC. So, Chair and members of the committee, this petition is not available to be accommodated for channeling because the petitioner himself has not alluded, has gone off the provisions of the Oaths and Statutory Declarations Act. That's the point I wanted to make.
Thank you very much. Chitamba. That is your name?
Geshamba.
Thank you very much. Geshamba, we hear you.
Thank you, Mr. Chair.
1 minute.
Yes, indeed. I would wish to first associate myself with the submissions of my colleagues. Okay. I would equally wish to highlight to the House on issues of Article 50 on the fair hearing, Section 3 and Section 35 of the Public Officers Ethics Act, and more importantly, Mr. Chair, Article 35 of the Constitution on access to information. It is our contention, Mr. Chair, that Article 35, on account of the petitions that have been presented before this House, has been greatly violated. And as my colleague, Mr. Nyaberi, has indicated, that all the petitions and the allegations before this House are not supported by any evidence. And if there was any evidence, and in line with Article 35, then this House is mandated to call upon the evidence to be supplied by the petitioners. And in conclusion, I will just indicate that perhaps, and on the face of the petitions, these are petitioners who have come out as persons who had their feelings hurt by the alleged actions on
actions of the four commissioners. And there is no forum under law that provides for hurt feelings. And definitely not this House. And as per your prayer, Mr. Chairman, and I would quote, that you sought that the deliberations be seen to be fair, just, and right. And we extend that opportunity back to the floor for the objections that have been raised before you to be given the due consideration on account of the lives of the petitioners before you. That is all.
Thank you very much. We've heard you. We need to give you some decision in a few minutes. The most important objection that you have raised is on jurisdiction. Because once we resolve that...
A point of order, Mr. Chairman. Would the other counsel for the other parties, petitioners, be given an opportunity to respond before, Chair, you take it on?
Which counsel?
For the petitioners. For the petitioners.
Does he wish to do so?
Procedurally,
you wish
yes,
to do so?
Mr. Chairman.
No. Yeah, he didn't ask you for it. I thought he was satisfied. But if he wants to say anything, let him say so.
I'll get my time and I'll respond at that particular time to all the issues raised.
Thank you very much. So the issue of the jurisdiction, your response would be we have a jurisdiction. So why don't we go and determine whether we have or we don't?
Yes, there is jurisdiction for this committee.
Chairman.
Chair, on the point of order. Of course, as a matter of procedure, which Chair, you know I don't want to belabor, Senator Kongo has a right to respond to the issues raised by the respondents. We are here as non-partisan, neutral people. We want to hear what he has to say. Or even if he has nothing to say, we want to record that he had nothing to say when called upon to speak.
He has forfeited, actually. So
thanks, Chair. Thanks, Teacher, for your compliments. I just say that I'm going to get my time, and at that appropriate time, I respond to the emerging issues raised.
Thank you very much. Thank you. I think that is sufficient for now. What we do, because more people are in here, it is the members who will move out. I will take them to the boardroom with the council, and in possibly maximum 20 minutes, we'll be back. So parliamentary council, so that they can guide us on everything. So in 20 minutes, maximum 20 minutes, we'll be back. And we shall give you a ruling. And please, from there, whichever way it goes, we must now proceed, or if we have no jurisdiction, we must terminate the proceedings. Thank you.
Jeanette, perhaps you can give me this a forum. Perhaps it's important for him to understand that he cannot respond to this issue once we have made a decision on it.
Chair, if that's the case, if that's the case, I'm guided. I stand guided. I didn't know that you were retreating to make a decision on this. Let me just make a few remarks
on the points of law.
On the points of law.
Please do not go to evidence, because much of it was on evidence.
Yes, Chair.
Mr. Chair, just for clarity, do we have a right to respond to what he will have said?
Let's hear it first, so that, you know, if you do that, then it is right to respond and what have you. I give you only 5 minutes, sir, to respond, especially on the issue of jurisdiction.
Most surprised, Chair. Chair, when when the first petitioner lodged the petition in Parliament, it was sent to the Speaker, to the Clerk of the National Assembly. And I understand, Chair, that petition was sent for scrutiny to the relevant legal department, which brought to this committee. So on matters jurisdiction, this committee has immense jurisdiction to make determinations whether the petitions presented have a prima facie case, as you collectively highlighted earlier on. Secondly, Mr. Chair, what I respond to is the document and letter sent by Senior Counsel Donald Kipkorir, and they are supported by other councils on the issues of
documents of evidence, affidavits to be attached to the petition, I need to refer them to the Petitions Procedural Act, which entails how a petition can find its way to Parliament. In that regard, our petition is in order and we are ready to present it, Mr. Chair. That's all I have to say.
Mr. Chairman, can I just...
Honorable Wanda, you are totally out of order. You cannot absolutely participate in these proceedings.
As Amisai.
No, you can't. I'm sorry, you know the standing orders. I'm going to refer you. Sorry. You cannot participate. Sorry,
Mr. Chairman, just give me a hearing.
Take your seat, please.
As Amisai.
I'm sorry, no.
Serious matters such as...
No, please. You are out of order, and if that is, I'm going to revoke your being here. You're out of order completely.
Point of order, Chair.
Sorry. Let me say this. Let me say it. We will have endless points of order. Gentlemen, raise whatever issue you have to raise when we go to make our decision.
No, Chair. That one now is the highest dictatorial way of handling a committee. Chair, let me raise this matter. I'm on the floor. Or I leave it.
Let's retreat, please.
No, Chair, that retreatment is what I want to speak on. Chair, the issues that have been raised by the lawyers, the preliminary objections that have been raised by the lawyers representing the respondents, Chair, are very, very heavy matters, Chair. They have raised issues. No, I don't need to retreat because what is done in private can be harmful to the public. Let us do our things in public so that people know, Kenyans know what we are doing. We are representing Kenyans. So, Vice Chair, I cannot do things in private. So, Chair, these issues are very heavy.
Thank you.
No, I'm going on. Chair, I'm proposing this. We want to digest those issues, analyze them, internalize them, so that we can come back when we are seized of these issues properly.
Thank you.
So, Chair, I stand on my feet to move a motion that we adjourn this committee officially for now until such a time when now we reconvene. 20 minutes cannot be enough, Chair, to digest issues that have been raised on jurisdiction, issues of fake names and wild chase bulls and hot airs. Chair, those things are very heavy.
We may actually need 5 minutes to do that.
We are not listening here to a presidential petition. We have all the time to analyze things in this committee, Chair.
Thank you very much.
One of the reasons why Parliament loses petitions all the time in court, Chair, is this issue of hurrying up the petition.
Thank you.
We are in a hurry to score politically. This is a political process and we want to score politically and we want to appease people that we have done our work. No, Chair. Let us adjourn the committee officially so that we can retreat and agree when to reconvene. That's our position. Actually, on the minority side, we want to consult more with our researchers,
Thank you.
our lawyers. Under standing order 230, we are allowed to consult experts. We want to go and consult experts on these issues. Some of us are laymen. The other day when we were in the committee,
Honorable Junet, please, you can't go on forever.
Let me finish. The other day when I was in the committee, we did not agree on this timetable, but you used some words. Somebody who's like me, who's not a lawyer, will not understand. Juriscata, jurisdicata. Those things I have to go and consult.
Thank you.
Yeah. I have to go and consult my lawyer, Chair. That's the position.
Thank you. We have enough representation for Parliament for advocates. Honorable Farah, I think we are happy. Anything else is going to be raised when we go to the boardroom. We have maximum 20 minutes. All right? So, hold on. It is in agreement. We have agreed.
Not in agreement, Chair.
We can use that 20 minutes,
20 minutes to listen to him.
decide
that we are not in agreement.
we are going again for 24 hours or so.
Thank you very much. Let's retreat.
Honorable Chairman, a point of order.
No.
Honorable Chair. Chairman.
Chair. That will do that. 24 hours.
Chair. Yeah. Honorable Chair. But it's also good to also remind Honorable Junet that in the timetable he says that we did not agree. He actually did not attend that meeting. And so he did not participate in it, but all the other members attended.
Chair, that's not true. Chair, that's not true. I attended the meeting. Chair, I attended the meeting. That's where you brought the issue of juriscata. I need to know what is juriscata.
Naam, so Dr. mtazamaji, ama kwa hakika mwenyekiti George Murugara alikuwa na kibarua kigumu. Na bila shaka mengi yametarajiwa kwa labda tumeweza kupiga hatua, lakini kama unavyoangalia mapema zaidi alikuwa ni mbunge Junet Mohamed ambaye alikuwa anasema anawakilisha wale upande wa wachache bungeni, akisema kwamba alikuwa ameandika barua kwa spika wa bunge ambaye ni si mwingine Moses Wetangula kuhusiana na maoni yake na mapendekezo yake kuhusiana na kanuni na baadhi ya sheria ambazo zitatumika kuendeleza kikao hichi, lakini kwa hajapata jawabu. Na alipokuwa anazungumza hivyo na akasema kwamba barua niliyomwandikia ni hii, na mwenyekiti akasema pia jawabu lako nao ndio hili, lakini walivyoangalia wakasema kwamba alina sahihi, hivyo basi hawezi amini, lakini lile likatupiliwa mbali na mwenyekiti wa kamati ile, na pakaibuka naye wakili Danson Omar akasema kwamba kabla tuanze pia wale ambao wanawakilisha wale makamishna nao pia wana maswala ambao wangependa yapewe kipaumbele kabla shughuli ianze.
Lakini wengi wanauliza, je, wabunge hao ama wale makamishna wengi wanatetea nini? Ama kwa hakika ni wengi wanasema kwamba ni kuondolewa kwa makamishna wale wanne, ambapo walalamishi ilikuwa ni Republican Party, mtazamaji, Reverend Dennis Ndwiga, Geoffrey Langat na Owor Jerry. Walalamishi hao, mtazamaji, wanaitaka bunge kuweza kupendekeza kubuniwa kwa jopo na Rais William Ruto ili kuweza kuwatoa wanne hao ofisini. Na
bila shaka mengi ameweza kuzungumzwa. Kumbuka mapema mwenyekiti kwa amesema watahitaji labda pengine kuchukua mapumziko ya dakika 20, alafu wakirudi watakuwa washapata mwelekeo na kuweza kujibu yale ambayo yameweza kuibuliwa na wale ambao wanawakilisha wale makamishna. Lakini pia umeweza kusikia Junet Mohamed mbunge anasema kwamba ikiwezekana tuvunjulie leo hii, tukakae tujipange, manake hoja zotolewa ni hoja nzito, hazizaweza kushughulikiwa kwa dakika 20. Tutafute siku ambayo tutakuwa tuna majibu ya kutosha, manake ni swala ambalo Wakenya wanalifuatilia. Lakini kabla tuzungumze mengi, nafikiri pia kabla tuende mapumziko kidogo, tumlete pengine kama wakili Charles kwa dakika moja ama mbili, utuambie umesikia hali ilivyokuwa. Wengi walitarajia kwamba leo labda itakuwa wale ambao ndio wanatarajiwa kuulizwa maswali na kutoa mwelekeo nini kilichojiri wamezungumza, lakini muda wote ambao tumeweza kuutumia ni kama ndio mwanzo tuanza kikao rasmi, maana lazima majibu yatolewe na baadaye uangalie kama upande utaridhika ndio vikao vianze. Tunaelekea wapi ukiangalia yale yaliyojiri katika kamati ya bunge?
Tumekuwa na vuta ni kuvute katika bunge kwa mambo mawili ya kisheria. Ya kwamba ni ya kwanza ni kitu inaitwa jurisdiction. Yaani uwezo, kama hiyo committee iko na uwezo ya kuangalia ile hoja ilipelekwa pale. Ya pili kuna kitu wanaita kisheria res judicata. Wanasema eti uamuzi ulishafanywa na Supreme Court ama koti kuu. So wanasema eti hayo ni mambo lazima watatue ya kwanza kabla hawa wenye waliwasilisha hoja yao wakuje waseme eti hao commissioner wanne wako na kosa ama hawana kosa. Kisheria hayo ni mambo lazima yazingatiwe ya kwanza kabla tumeenda kwa wakati mwingine. So vizuri kwamba committee waone kwamba wako na nguvu ama wako na uwezo ama wako na jurisdiction. Kwa sababu kwa mambo ya jurisdiction nasema katika katiba, mtu akifanya tendo kama kwa ofisi na kuna kitu tunaita good faith, hakuna haja ya kukuja tena na hoja useme eti amefanya vibaya. Ni kitu chenye wanasema ni watu wanakuja tu kudhulumiwa kisiasa. Na hayo si mambo yenye inaweza tusaidia kama nchi. So wameenda dakika 20 wanaenda kuongea na mawakili wenzao, na hata umeona pande nyingine ya minority ya kina Junet wanasema eti wanaenda kuangalia na researchers na mawakili wao ili waone eti itafanyika aje. Kwa sababu kama hayo mambo hayajatatuliwa hatuwezi enda mbele. Hii process lazima ikuwe kitu kila mtu anasema ni fair. Kila mtu anaona eti sheria imezingatiwa. Hakuna kitu yenye tume step ili tukirudi tutajua tunaenda wapi.
Na kama mwanasheria wewe na kama wakili, kama tile na nguvu ya kuweza kushughulikia na swala hili la kutaka kuweza kuwabandua ama kuondolewa kwa makamishna wale katika tume ya IEBC kisheria na kiuwezo, je, wako sahihi kuendeleza vikao vile ama kisheria wako sahihi kushughulikia swala lile? Kisheria
kamati hii iko na nguvu kwa sababu sheria nasema kwamba kama mtu wa commission, independent commission kama hii IEBC, kama kuna tashwishi kwake na wanataka kumtoa, unaenda kwa bunge kwanza. Unapeleka hoja ama inaitwa petition. Petition ikishasikizwa kama hiyo committee ya Justice and Legal Affairs, alafu wanaenda bungeni. Hapo tunaenda kwa rais wa nchi. Ndo sasa atabuni kitu inaitwa kikao inaitwa tribunal ili kuangalia hayo mambo, na wakati huo pia rais wa nchi anaweza sema kwamba wakae kando, wakuwe suspended kando, alafu wazingatie hayo mambo. Kwa sasa hawa wako na jurisdiction ama uwezo ama nguvu wa kufanya hivyo. Ni tu mjua sheria ukienda, kila mtu lazima aseme tu upande wake, mimi venye naiona. Na kila mwenye amepelekwa pale na wakili wake ni